Okay.
Sorry.
That's going to sting.
Sorry, thank you.
That's okay, no problems. You okay now?
Yeah, thanks.
All rise if able. The applications are included in the matter of JNFX Ltd and Giwa.
Yes, Mr. Daddy.
Well, as I appear together with my learned junior, Mr. Joseph Wigley, on behalf of the Appellant company, JNFX Ltd, and I hope I'll be forgiven for on occasion referring to it interchangeably as either the Appellant or JNFX. And my learned friends, Mr. Matthew Bradley, King's Counsel, and Mr. Raymond Cholikoff, appear on behalf of the Respondent and the Claimant in the underlying litigation, a Mr. Giwa. There are two other named defendants to the proceedings, the second defendant, Mr. Ashay Mervyn, and the fourth defendant, Frontier Financial Technologies Limited, that being a Nigerian company, of which the second defendant is a director and which is unconnected to the appellant. Neither of those defendants were present or represented in the hearing below, and neither are participating in this appeal. Just for completeness, the claim as against the third defendant had been discontinued by the claimant prior to the hearing below. Can I just check as a matter of housekeeping, your Lordship should have a core bundle and a supplementary bundle. I'm not sure whether your Lordships are working in hard copy or electronically, but if it's in hard copy, there should be 2 volumes of the supplementary bundle. There should also be a very slim bundle containing an additional clip of correspondence and enclosures.
We don't have that in a bundle, but we have it loose, yes.
Oh, I'm grateful. Apologies for the lack of a bundle. And that, but your Lordships will know that is the subject of an application pursuant to the Court's case management powers to, in effect, add that short clip to the supplementary bundle. The key documents being 8 pages by way of enclosure to correspondence, and those 8 pages are contemporaneous documents which were in the hearing bundle below, but not yet in the supplementary bundle. And there's also an application within the appellant's notice to adduce new evidence in the form of Mr. Stephen Elam's second witness statement dated the 5th of June 2024 and the accompanying exhibit. Your Lordships will be aware that both of those applications are subject to the directions of this Court that they be dealt with at the same time as the appeal. As we understand it, the application to add the additional clip to the supplementary bundle, although it's not agreed as such, it's not opposed, but the application to admit the new evidence is. My learned friends invite your Lordships to address that at the outset of this hearing, but for efficiency and to address the new evidence in context, we intend to address the Court in relation to those applications where they arise in the context of the submissions on the underlying appeal. And with that housekeeping out of the way, I'll turn to the substance of the appeal itself. Before I move to address your Lordships in relation to each of the 6 particular grounds that are articulated in the appellant's notice, and noting that permission to appeal has been granted by Lady Justice Falk in relation to all of them, I do want to make some what I might call introductory and overarching submissions to then place those 6 grounds in context. The first of those overarching submissions is in relation to the context in which the relevant order under appeal was actually made. And then secondly, I want to address the Court in relation to the law on the threshold test for granting summary judgment in a case such as the present, which we obviously submit the Deputy Judge.
Yes, well, on that latter point, I think you can take it that the members of the Court are pretty familiar with that.
Indeed. When I come to it, though, I hope I'll be forgiven just for highlighting the salient passages, particularly in circumstances where we say the Deputy Judge below correctly summarised the principles, but our submission is that he failed to apply them properly. So I do want to highlight a few points, if I may, but I'll do so as quickly as I can. Turning then to the context and the order below, your lordships will have seen the judgment. Will have seen the judgment and the order below. They're at tabs 5 and tab 6 of the core bundle. And as regards the underlying claim, the amended particulars of claim for which are at tab 9 of the bundle, your lordships will already be aware that, in summary, the respondent sought 2 forms of relief against JNFX in respect of 10 alleged oral contracts, which were claimed to have been entered into over the course of a year and in some respects subsequently orally varied. Those contracts being, so it's said, for the exchange of Nigerian naira into US dollars between, on the one hand, the second defendant, Mr. Mervyn, acting as agent with actual or ostensible authority to bind my client, on the one hand, and on the other hand, being the respondent and or Multi-Choice Nigeria Limited, which I'll refer to for convenience as Multi-Choice, on the second part, and with the respondent having taken an assignment from Multi-Choice of any claims that Multi-Choice may have against JNFX in relation to those contracts. And crucially, those 2 forms of relief were firstly damages for breach of contract in respect of various alleged shortfalls in US dollars, which the respondent alleges should have been delivered pursuant to the claimants as varied. Those are referred to as the contractual claims. And we emphasise at the outset that the contractual claims relate to alleged shortfalls, because on the claimant's own case, the first 9 alleged contracts were all either wholly or partially performed. And then secondly, the form of relief sought was damages for deceit. And as against my client, that was on the basis that it was alleged that JNFX should be held vicariously liable for deceit on the part of the second defendant, Mr. Mervyn, in respect of various sums of Nigerian naira, which were said to have been paid pursuant to such alleged contracts, and in respect of which the claimant contends there is either a shortfall in US dollars or no relevant refund of naira. Those Nigerian naira having been paid to 2 separate Nigerian companies, those being Chamswitch Limited and the 4th defendant, Frontier Financial Technologies Limited, neither of which, as I said, are connected to the appellant, but are instead seemingly controlled by Mr. Mervyn. And just to be crystal clear, it is common ground that not one of the 132 payments of naira, which are relied upon in Annex A to the particulars of claim, were ever paid directly by the respondent to JNFX. Those transfers were only ever made to one or other of the 2 Nigerian companies controlled by the second defendant. And I believe it is now common ground that neither of those entities are connected in any way to JNFX. But just for completeness, can I just show your lordships the first witness statement of Mr. Elam in the supplementary bundle volume 1 at tab 6C. On page 275. That point's made at paragraph 21. See, JNFX denies that it nominated or controlled any account into which Mr. Giwa deposited any naira. JNFX does not own, control, or otherwise...
Sorry, I seem to be on the wrong page.
Oh, sorry, I'm so sorry. Page 275.
Yes.
It should be behind tab 6C.
Yes. And which paragraph?
Paragraph 12.1.
Right, thank you.
This one, it may be the case Mr. Mervyn instructed Mr. Giwa to transfer the naira into such accounts. JNFX denies that it nominated or controlled any account into which Mr. Giwa deposited any naira. JNFX does not own, control, or otherwise have access to any bank accounts in Nigeria. It's explained it has no association or relationship whatsoever with Chamswitch or Frontier, doesn't have access or control over those accounts, and no naira was transferred by Mr. Giwa was ever received into an account operated by JNFX. I should also note that whilst some of the payments of US dollars, which the respondent contends were in partial fulfilment of the UNED contracts, were made by JNFX, only 14 of the 32 receipts, which have been detailed in Annex B to the particulars of claim, came from accounts which JNFX controlled. All the other relevant payments of US dollars came from third-party accounts with which JNFX has no connection. If your lordships would turn up in the core bundle, the particulars of claim are at tab 9. And at page 233 through to 237 is Annex B to the particulars of claim. These are the payments of US dollars which Mr. Giwa says were received by MultiChoice. And your lordships can see that while some of those come from JNFX, others come from OOE Integrated Services, Yellow Card Financial LLC and ProTrade Group. And the respondent has explained in evidence that Yellow Card is a cryptocurrency exchange and that ProTrade is a cryptocurrency broker. Your lordships note the reference to that is paragraph 67 of Mr. Giwa's first affidavit in supplementary bundles at page 164. And again, just for completeness, at page 298 of the bundle in the defence, your lordships will see at paragraph 38 the averral that those accounts from which those other US dollars came are accounts which are nothing to do with JNFX and of which JNFX had no knowledge or connection. And JNFX's position, as we've summarised in paragraph 9 of our skeleton argument, is that its role in relation to these alleged contracts was only to provide remittance services in circumstances where the second defendant provided it with US dollars to transfer to MultiChoice. Its position is that these contracts were not entered into on its behalf. And the application for summary judgment, as issued by the respondent in September of 2023, sought summary judgment in respect of all of the claims against the first defendant and correspondingly sought the striking out of JNFX's defence in its entirety. By that time, no further steps had been taken in the proceedings. And by the time of the hearing below, the only further procedural steps, save in respect of evidence on the summary judgment, had been the provision by JNFX of a response to a request for further information that related to its averral that any exchange transaction in respect of Naira into dollars by JNFX would be illegal as a matter of Nigerian law. And there was also the service of a reply by the respondent. Again, by the time of the hearing, the appellant had provided a draft amended defence, and it's the draft amended defence I'll refer your lordships to, which is at tab 11 of the core bundle. And the position taken below by the respondent was that the amendments to the draft amended defence, given the stage of the proceedings, were effectively consented to, subject to the determination of the application for summary judgment. And consequently, the application for summary judgment is heard and determined at a relatively early procedural stage. And crucially...
One would expect. What's surprising about that?
Well, crucially, we say that's in advance of any DRD identifying the list of issues for disclosure. It's in advance of any extended disclosure, and obviously in advance of exchange of witness statements and evidence. And by the time the summary judgment...
I'm still struggling to understand why you say that's significant. I would understand it was significant if there'd been a late application for summary judgment, but since it's entirely conventional to launch a summary judgment application at an early stage, our point is to avoid the need for disclosure of witness statements. So what's the point you're making?
Well, it is, but as made, the summary judgment was sought in respect of all of the claims. And by the time the application comes to be heard, with no forewarning having been given, save until the receipt of the skeleton argument of my learned friends, by the time one gets to the hearing, summary judgment is effectively abandoned in relation to all of the contractual claims. And the opposition to the summary judgment had been very much premised on the basis that these contractual claims raise triable issues. They need to go to trial. There needs to be full disclosure of evidence and it to go through the ordinary trial process. And in fact, when one looks at Malone Jr.'s skeleton argument for the hearing below, not having been given forewarning of that position, there's actually only a very small part of the skeleton that's focused on the deceit claim, because it focuses on everything. And quite properly in our submission, the response taken to JNFX in response to that summary judgment hearing was that it's not appropriate in the context where one has all of these contractual claims, bearing in mind all the various issues that were in dispute. And as I say, one sees from paragraph 7 of the order below that the respondent's application, insofar as it concerned the contractual claims, is dismissed completely. And if I can turn to the judgment at tab 5 of the core bundle.
Why was it dismissed if it had been withdrawn? Does it make any difference?
Well, I suppose there's no application to formally withdraw. My learned friend may be able to say, I don't think it does make any difference. What was plain was that the respondents accepted that the contractual claims themselves raised triable issues.
You put in opposition the
Yes.
fact that the contract you said would be illegal under Nigerian law. The claimants say they recognised that although they took a different view, that was a triable issue. So they didn't pursue the contractual claims. That doesn't seem to me to be at all surprising.
Well,
Does it? My question was: does it matter whether it's dismissed or whether it's just dropped, formally or informally?
no, because in either event, the respondents recognise that the contractual claims need to be determined at
Yes.
trial. Is ultimately the point.
Yeah.
But it's relevant also because, in fact, one then doesn't have, in the context of the summary judgment hearing, an analysis of all the relevant contracts of where one gets to in terms of the account and the computation of the shortfall, which is a point I'll come on to.
I see. Thank you.
Going then to the judgment at tab 5, if I can just refer to paragraph 6, your lordships will see the point I've just made, that so halfway down the page, and in fact that's the point Justice Nugee has just made to me, that Mr. Giwa was accepting that the issue of illegality under Nigerian law raised tribal issues, and it therefore based its present application on what he says are those aspects of the claim which are unaffected by that. And then one sees in the final sentence, as against JNFX, for the purposes of the present application, his claim is founded on JNFX's alleged liability for Mr. Mervyn's deceit. Mr. Giwa maintains other contractual claims against JNFX in respect of the multi-choice contracts, but those claims are not subject to the present application because of Mr. Giwa's acceptance that they raise tribal issues. So the whole of the contractual claims was a matter that was going to trial. And in addition, over the page at paragraph 9, your lordships will see, so top of page 168, that in light of the position taken by Mr. Giwa on the application, it's unnecessary to consider JNFX's submissions on Mr. Mervyn's alleged lack of actual authority, although Mr. Giwa maintains Mr. Mervyn's authority was indeed actual, not just ostensible, and secondly on the issue of illegality. The point there being that the summary judgment application necessarily proceeded on the basis only of ostensible authority. And the argument that the second defendant had any actual authority to bind my client was not being made. And what then happens after hearing submissions from our opponents and my learned junior over the course of what I'm told was only 1 3/4 days of court time, judgment obviously refers to 3 dates, but we say it's relevant that the hearing commenced at 2 o'clock on the first day, occupied the court for the full day the following day, and then only ran for approximately an hour on the third day. After that hearing in his reserved judgment, the deputy judge grants summary judgment in favour of the respondent on the deceit claim against the appellant and awards damages in the precise sum of, get this right, 7,916,209,196.50 Nigerian naira, together with compound interest thereon. And in doing so, although the contractual claims themselves are rightly left to be determined at trial, the deputy judge necessarily gives partial summary judgment on 2 further related issues. He determines first that the second defendant had ostensible authority to act as JNFX's agent in entering into any contracts, but without making findings in relation to those contracts, and that JNFX's standard terms and conditions published on its website would not have been incorporated into such contracts with Mr. Giwa, again, but without making findings in relation to the terms of those contracts. And it was necessary for the deputy judge to determine both of those issues adversely to JNFX to grant summary judgment on deceit. Now, in our submission, the deputy judge appears in paragraph 10 and 11 to correctly identify the legal principles, but as I submitted at the outset, it's our submission that the deputy judge erred in his application of them. And whilst we aver 6 separate grounds of appeal that have been articulated in the notice of appeal, they all fall under the same umbrella complaint, which we set out in paragraph 5 of the grounds of appeal, namely that the deputy judge firstly wrongly conducted a mini-trial on the issues and the evidence that was before him, and secondly failed properly to take account of the fact that firstly at trial the burden of proof would fall on the respondent to prove his case rather than on the appellant to disprove it, and in various respects the judge appears to have started from the premise that the respondent's case was right unless the respondent could knock it down. And then secondly...
Is that right? I thought the burden of proof on a Part 24 application by the claimant was on the claimant.
Yes, so the respondent being the claimant, and we say that the deputy judge failed to take full account of the fact that the burden of proof was on the claimant, and instead seems to have approached it on the basis that the burden of proof was on JNFX.
Okay.
I don't recall that being amongst your grounds of appeal. I mean, you certainly say he's wrong to find that there's no triable issue on various points. I didn't recall. I may be misremembering that wrong burden of proof was a ground of appeal.
If your lordship would go to page 16 of the core bundle, it's at paragraph 5 at the bottom of the page of 6. So this is our grounds of appeal appended to the notice of appeal. And the point I'm summarising here is the point we make in paragraph 5 of that document.
Yes, but it's not one of the grounds. I mean, and we'll come back to what you say in paragraph 5 in a moment, but I'm looking at grounds 1, 2, 3, 4, 5, 6. Maybe I'm misreading, but at the moment it's not leaping out to me that any of those distinct grounds is saying the judge applied the wrong burden of proof. Now, if I'm mistaken, please tell me.
Well, we say in paragraph 5, referring to the legal principles, we say the judge erred in applying those principles in respect of each and all of the 6 grounds identified below.
Right, okay.
So those points that we make in paragraph 5A and B, in our submission, the point we're making there is apply to each of the 6 grounds.
All right. But then what does B actually mean? Failing properly to take account of the fact that at trial the burden of proof will fall on the claimant to prove its case. I mean, that's just like so elementary. I mean, in what respect do you fail to take that into account?
In the defence, JNFX makes plain that various matters are not, by nature of the circumstances, are not within its knowledge. And so, quite properly, it pleads at the stage of defence non-admissions in relation to various averals. The effect of that non-admission is the issue is disputed because it requires the claimant to prove the matters which are alleged. And in
Sure, yes.
yes, and in our submission, the judge failed to take full account of the effect of the non-admission.
But
And in-
I'm sorry, my question is obviously badly phrased. Let me try and rephrase. I can understand a submission that says the judge applied the wrong burden of proof. That's a clear error. But that's not how you're expressing it. You're saying he somehow failed to take into account the burden of proof. And I'm not sure I understand that submission if you're not saying he's applied the wrong burden.
But, my lord, it's perhaps a point that's best addressed under the heading of each of the individual grounds, but I'll try to make good what the question that we say the judge identified and answered, and how we say the judge should have phrased the question in relation to each of those grounds, having regard to where the burden of proof lay in circumstances where there was a non-admission. I mean, there are various...
It seems to me that the analysis is entirely straightforward. The claimant has to prove its case, and all the more so if it's summary judgment. End of.
Yes, yes. But by way of example, but I'll come to it under ground 6, when the judge deals with quantum, the judge doesn't go through a careful analysis of the facts which are averred by the claimant in support of its calculation in relation to quantum. It seems to take it as read and only deal with a positive point that's put forward in relation to an aspect of it that's advanced by JNFX by way of denial. What the judge doesn't deal with is the non-admission in relation to the full computation of the quantum. And indeed it couldn't go through that exercise in the space of a day and 3 quarters.
Okay.
And just for completeness, the other points we make there are the judge, we say, failed to take account of the early stage at which the application was made, insofar as that was relevant because one hadn't yet got to extended disclosure. And we say, and I'll make the point repeatedly under the grounds of appeal, that the judge failed to take into account that there were reasonable grounds for thinking that a fuller investigation in relation to the facts might add or alter the evidence that would be available for the trial judge.
And just help us on that. How does that assist you when the key item of evidence lies in your own client's hands and you're resolutely refusing to disclose it? Namely, the statement you took from Mr. Mervyn. Of course, it's privileged, you're entitled to refuse to disclose it, but that would be the simplest way of shedding some light on matters, wouldn't it?
My lord, I've seen no such statement. There's no acceptance that there is indeed any such statement. There's an inference drawn by the claimant by reference to exchange in WhatsApp.
Are you instructed to deny it?
I don't have any instructions on that. Well, I'll come back to that if I may later. But that certainly is no admission that there is any such statement. And I'll look over the lunchtime adjournment if I may in relation to the particular language in relation to the defence. But that was an assumption made by the judge that it did in fact exist. And sorry, forgive me, just for completeness, we say that the judge did fail to take into proper account that following disclosure, and indeed at the trial of the contractual claims which would take place, given that the summary judgment was only partial summary judgment, there would be extended disclosure from the respondent, disclosure from multi-choice. There would be the opportunity for the appellant to make various inquiries of third parties, and in particular in relation to the accounts in respect of which money was said to have been received, and that hadn't been done at that early stage of the proceedings. And Mr. Elam's explained in evidence why it was appropriate for that not yet to have been done, because one hadn't at that point identified the list of issues for disclosure, and one didn't yet know what might be forthcoming from multi-choice. A point that's made in particular in our skeleton argument is that neither JNFX nor the Deputy Judge had full visibility of the evidence at the stage of the summary judgment hearing. We make the point in paragraph 12.3 of our skeleton argument that whilst the respondent had exhibited WhatsApp exchanges spanning some 122 pages, those WhatsApp exchanges had been heavily redacted and appeared to be incomplete. Redactions can be seen by way of example in the supplemental bundle at tab 8EE. Don't propose to take your lordships to them because it's not in dispute that they're redacted, but by way of example, page 419, 475 and 484. And they're also incomplete insofar as there are no messages that have been disclosed in the period between 24th of May and 26th of July 2021. And they also contain images and photos that were not reproduced. And nor in our submission have all relevant communications between the respondent and multi-choice, which could reasonably be expected to shed light on the issues, been provided. Moreover, all of those documents will fall for disclosure and consideration on a trial of the contractual claims. I do then, and also I bear in mind the point that's already been made to me by your lordships in relation to familiarity with the threshold test in relation to entering summary judgment, but bearing in mind the nature of our submissions, I do want to counter through them, if I may. The court will obviously be familiar with the language of CPR 24, but it behoves emphasis that there are two things that the respondent had to establish. Firstly, that there was no real prospect of JNFX succeeding on its defence in relation to the deceit claim, and that there was no other compelling reason why the case or issue should be disposed of at trial. And obviously it's well established that to defeat an application for summary judgment, the defendant has to show a prospect of success which is real, in the sense of not being false, fanciful or imaginary.
Just on that last point, just
Yes.
to be clear,
Yeah.
I'm not sure it matters, but is it your submission that the applicant for summary judgment bears the onus of establishing an absence of other compelling reasons for trial,
Yes.
even if it has established no real prospect of success?
Yes.
Because one might have thought that if the claimant establishes no real prospect of success in the defence, the onus is then on the other party, the respondent to the application, to show that there is some other compelling reason for trial.
Lordship, just bear with me for one moment. The reason I say definitively yes, my lords, is that what I had in mind is that when one makes an application for summary judgment, there are specific requirements as to what the applicant must state in the application notice. And forgive me, that's what I was just looking for in the white book.
But how do you prove the negative? If you're the applicant for summary judgment, it's one thing to say, okay, well, my claim is unanswerable and therefore defence has no real prospect of success. How are they supposed to show the absence of other reasons for trial? Well, surely it's for the respondent to say why, even though it has no real prospect of success, there's some other reason for trial.
But the CPR require the applicant for summary judgment to state that they, the applicant, know of no reason why the disposal of the claim, defence or issue should await trial. So they have to consider the position and aver that. The position of the respondent here is the very fact that the contractual claims were going to trial is a highly pertinent point.
To be sure, but that's a point you're putting forward, and understandably so.
Yes, but ultimately the burden of proof as to whether or not summary judgment should be entered must necessarily fall on the applicant.
Well, to be sure, but it's, I'm talking about the evidential burden with regard to other compelling reasons.
Yes, I appreciate evidentiary burden is a different aspect, but ultimately the threshold test that the applicant has to satisfy, and which the deputy judge ought to have been satisfied by, which required him to consider, therefore, both limbs.
What if you're a claimant and you don't think there's a defence, and you put in evidence saying, I don't think there's a defence, I can see that the practice direction says you also have to say you don't know of any reason why there has to be a trial. But I'm finding it very difficult to imagine circumstances in which a claimant would be in a state of mind in which they can see, I've got a good claim, I don't think there's any defence. But nevertheless, I know it ought to go to trial. What sort of reasons would a claimant ever have for thinking there should be a trial if they thought their claim was an undefendable one? I really struggle with that. I understand the court may say, we're not satisfied there's a defence, but nevertheless it should go to trial. There are reasons, it's the same with appeals, there are reasons why the court may take that view. One of the examples in the cases is a claim looks like a good one, but it's such an unattractive one, but if it's to be given judgment at all, it should be in the full glare of publicity, that sort of thing. But I find it very difficult to imagine in what circumstances a claimant is going to say, actually, I do know why there should be a trial, despite the fact there's no defence.
Well, again, I'm anticipating where I'll come to in relation to ground 6, but here in our submission, the issue of quantum is a really important point, because as I'll come on to, there's a very, very long analysis by the respondent in relation to how they compute the quantum, an analysis which involves the respondent, again, as I'll come to, accepting that there are difficulties with that analysis, that it's imperfect, can't be sure about various matters, various mistakes have been corrected along the way. But on any view, in our submission, that assessment of quantum was not something that was appropriate for summary determination. And that's an issue, with respect, we would say, was a matter plainly should have gone to trial, in the light of full disclosure, which had not yet been provided.
Okay, thank you.
Sorry, I'm conscious of the time, but I do want to just whiz briefly through the authorities, recognising, of course, that this court is familiar with them. But it is obviously conventional to refer to the relevant principles in paragraph 15 of the judgment of Mr. Justice Lewis, as he then was in the Easier case. Which
most of us have read many times. Yes.
I appreciate that, and there's a few points I do wish to highlight. So in the authorities bundle at tab 5, there's a recitation of that paragraph in this court's judgment in the Price and Flitcroft case, page 214. And again, appreciating the court's familiarity with it, we're obviously saying this is, we're obviously relying on the fact that the court must not conduct and a trial. And points that we would emphasise at paragraph Roman numeral 5, that in reaching its conclusion, the court must take into account not only the evidence actually placed before it on the application judgment, but also the evidence that can reasonably be expected at trial. And again, by way of emphasis at 6, that although a case may turn out at trial not to be really complicated, it does not follow that it should be decided without fuller investigation into the facts at trial. Thus, the court should hesitate before making a final decision without a trial, even where there is no obvious conflict of fact at the time of the application, where reasonable grounds exist for believing that a fuller investigation into the facts of the case would add to or alter the evidence available to a trial judge and so affect the outcome of the case. That point, again, is picked up in 7 over the page at the 5th line down. If it's possible to show by evidence that although material in the form of documents or oral evidence that would put the documents in another light is not currently before the court, such material is likely to exist and can be expected to be available at trial, it would be wrong to give summary judgment because there'd be a real as opposed to a fanciful prospect of success.
Sorry, where were you reading from?
Sorry, at top of page 215.
Thank you.
We do obviously rely on full recitation of that, but those are points of emphasis that we want to make. And I do then also want to take your lordships briefly to Doncaster Pharmaceuticals Limited.
What do we get out of that we don't get out of the entirely accurate summary by Mr. Justice Lewis?
So what does one get out of Doncaster?
Yes, I mean, he summarises it in little Roman 6, which you've just taken us to. So what do we get out of the full authority that we don't get out of the summary?
Well, in my submission, what one gets is the statements of principle in relation to exercising caution, and that the ordinary starting point is that there should be a trial. I'll take your lordships to the paragraphs as quickly as I can. Page 103, paragraph 4. That's the point that that supports the submissions that we've already made. And then
what does that support?
Well, so that they're designed for the swift disposal of straightforward cases.
Thank you.
And where there's no other compelling reason why the case should be disposed of at a trial. Point I was addressing Justice Arnold in relation to.
Well, actually, when you read that sentence, Lord Justice Munry clearly puts the onus on the applicant to demonstrate that the defence has no real prospect of success. It doesn't, in turn, say it's for the applicant to demonstrate there's no other compelling reason. It just says, and if there is no other compelling reason. I very much doubt anything turns on this, but it's not obvious that supports a submission that there's an onus on the applicant. In practice, if someone wants to say there ought to be a trial, it's for the respondent of an application to say, no, there has to be a trial, because even if there isn't a real prospect of success, here's another compelling reason. Isn't that realistically, in practical terms?
In practical terms, when one's dealing with the evidentiary burden, I quite accept that.
Yeah.
But the threshold for whether the judgment should be entered in the first place obviously remains the same.
Yes, I understand that. Can I be sure I understand it? Did you put forward before the judge, separately from your defences on the merits, as it were, an argument that there was some other compelling reason for a trial?
I was not at the hearing
I know you
below.
weren't.
I believe I know the answer to that, but if I may just turn my back.
Of course.
It's fair to say that the point was made repeatedly by my learned junior that there needed to be a trial because there needed to be full extended disclosure of all the material that was available and a testing of the evidence in circumstances where multiple non-admissions had been raised.
Yeah, but that's the argument no mini-trial, and that's the key area the judge made you say he did conduct a mini-trial.
Yes.
It's not a separate point.
I mean, my personal experience, for what it's worth, is Order 24 almost always proceeds on the basis that there is something which needs further investigation because you can't determine it with sufficient confidence at this stage. It's very rare for a defendant, or if it's a reverse summary judgment, a claimant, to say, well, even if you're against me on that, and you can decide there's no real prospect of success, I've got another reason why there should be a trial, because in the nature of things, those are very unusual types of case. So my question was, did you put forward, when I say you, obviously I mean your latitude, a separate reason, other than that, you can't safely determine the merits at this stage, which is effectively there is a prospect of success. Is there some other compelling reason? Because if not, I think this is really a red herring, this second leg.
The point of distinction in this case is that the contractual claims were going ahead to trial. So,
I see.
insofar as one might look at summary judgment and say, well, this will reduce the issues for the scope of the trial, and that therefore there is some sense in giving partial summary judgment on various issues because it reduces the scope of the trial. That's not so here.
Okay.
So that is a point of distinction which does fall under that second head, that there was a real reason to leave this to trial where everything was going to be looked at again anyway.
Thank you.
And again, I appreciate I'm at risk of irritating the bench, but we do emphasise the points that are made at page 105 by Lord Justice Mummery, that even though the case may turn out at trial not to be really complicated, it doesn't follow that it should be decided without further investigation. That point we say is obvious, and again, it's accepted on both sides, and indeed said by the judge, that it's well settled that the court must exercise caution and avoid a mini-trial because it runs the real risk of producing summary injustice. And it's the last paragraph where we say the court should hesitate before making a final decision when there's no obvious conflict of fact at the time of the application. There are reasonable grounds for existing that a fuller investigation would add to or alter. Lastly, then, just do need to take your lordship briefly to the Ocrabi decision of the Supreme Court in 2021, which is at tab 6 of the authorities bundle. And the purpose in referring to this authority is to make the point that in order to enter summary judgment, the court needs to be satisfied that all of the documents go one way. Obviously, it's under the heading that you mustn't conduct a summary trial on the merits, but all of the documents and material has to go one way. This is a judgment, as your lordships will probably well know, in the context of a jurisdiction challenge. But if I can go to Lord Hamlin's judgment at page 233, the proposition in relation to it being all the documents that must go one way is derived from Lord Hope's judgment in the Three Rivers District Council case, the relevant paragraphs of which are recited at the bottom of page 233 over to 234. I'd invite your lordships to reread that, perhaps more at leisure, but over the page at little letter, just below little letter B, where Lord Hamlin's talking about those cases in which summary judgment would be appropriate, because it may be clear beyond question that the statement of facts is contradicted by all the documents or other material on which it is based, and picks up on what Lord Wolfe says in Swain and Hillman, that the object of the rule is really designed to deal with cases that are not fit for trial at all. emphasising the point that there should be no mini trial on the evidence. And then jumping to page 250, again, we're making the proposition, picking up on that recital from Lord Hope's judgment, that summary judgment is only appropriate in clear cases. Again, in a sense, it's stating the obvious, but because we say the judge fell into error, we would ask your lordships to read paragraphs 110 and 111. They're making the point that it is only in a clear case where all of the documents go one way that summary judgment is appropriate. So we've marked up paragraphs 110, 111, and then 120 through to 128. And I should just pick up at paragraph 126 on page 253. Since the court's making a decision on the evidence, it effectively has to conclude that the prospect of there being further relevant evidence on disclosure could and should be discounted. And lastly, in paragraph 128, in terms of what one has to take into account in terms of the likely prospect of further evidence being available, it's not that there's a clear prospect that new material will become available, it's that it may. Which makes sense in circumstances where one has to discount the possibility of further relevant evidence. So I'm obviously at risk of repetition, but in our submission we say the Deputy Judge did wrongly conduct a mini-trial on the evidence that was available to him, and in doing so wrongly concluded that there were no reasonable grounds for believing the disclosure and cross-examination of the witnesses at the trial that was going to happen in relation to the contractual claims that might materially alter the evidence which was relevant to whether or not JNFX had a real prospect of successfully defending the deceit claim. And on that, and again, forgive me because this is elementary, but I do need to respectfully remind the court of the necessary elements for a claim in deceit, because that's the headline under which we'll address a number of the grounds. They're obviously not in dispute, and to the extent that it's helpful, we can hand up the relevant definition from Clark and Lindsall, paragraph 1701. I don't believe in this forum I need to do that, but in essence, it was necessary for the respondent to satisfy the Deputy Judge that there was no real prospect of the respondent not succeeding at trial on proving each of the following: that a relevant representation was made, that it was false at the time that it was made knowingly without belief in its truth or recklessly, or insofar as it's said to be a continuing representation, that it's false at the time that it's relied upon, and that the respondent under a multi-choice in fact relied on the asserted false representations to its detriment.
Is it sufficient if Mr. Giwa himself relied on it? I mean, he is, for these purposes, an agent of multi-choice. That's sufficient, isn't it?
The slight difficulty I have in answering your Lordship's question is that, and this is a common theme, the contractual claims are all going to trial. There is no specific finding at the moment in relation to who the contracts are between. In our submission, if the contracts are between, if it transpires at trial between whether it's the second defendant with ostensible authority or not, or JNFX on the basis they succeed in proving he has actual authority, if the contracts are between JNFX and multi-choice, it will be relevant whether multi-choice relied upon it.
Well, but if the contracts are between JNFX and multi-choice, it will be contracts made by Mr. Giwa on behalf of multi-choice. So he will be an agent for the purpose of entering into those contracts. So why is it not sufficient if he relies on it? I mean, what actually happened was that he procured payments of Naira from multi-choice into an account which he had access to, and then from accounts that he had access to into an account that Mr. Mervyn was associated with. Why is that not enough in terms of reliance?
What?
If he sends the money to Mr. Mervyn's accounts?
Without more, it would be, but one doesn't know whether or not. I don't think this is going to matter in terms of where we're going. But if, for example, there was evidence from multi-choice which established that it positively didn't pay any regard, then that in itself might be relevant. But I don't think I need to go there. So can I pick up then on the substance of the first ground in relation to the judge finding that JNFX had no realistic prospect of showing that the use representation was not made, and in determining that there were no reasonable grounds for no reasonable grounds for believing a fuller investigation into the facts would add to or alter the evidence available to the trial judge. We address this at paragraphs 13 to 15 of our skeleton argument, but if your lordships return to paragraph 12 of the judgment, which is in the core bundle, page 168, tab 6. So at paragraph 12, at the bottom of the page, one sees the relevant representations which it's alleged were made, and which in effect the judge finds JNFX has no real prospect of demonstrating they're not made. Now, we'll see starting at the bottom. So it's alleged he falsely represented that he intended that the Naira sums deposited into the frontier account would only be used to be exchanged into dollars in performance of the multi-choice contracts. That's the use representation. It's only the use representation which we address in relation to ground 1. And then secondly, is a recitation of the payment representation. Now, for the purposes of granting summary judgment on the claim in deceit and determining that JNFX has no real prospect of demonstrating that they're not made, the judge has to, in effect, have made a finding that they were made. But in our submission, it's notable that the judge nowhere in the judgment makes any express findings in relation to how it's said those representations were made. And instead, and this is a burden of proof point, we say seems to have regarded the burden of proof as being on JNFX to prove a negative. It starts from the proposition that they were made, and it's for JNFX to establish otherwise. And in our submission, we say the judge fell in error in not making any finding as to how that representation is said to have been made, but also in our submission, in light of the matters which we address in subparagraphs 14, little Roman 2 through to 4, the judge was wrong to reach that conclusion in any event. If I can take those in turn. Firstly, as we've noted in 14 Little Roman 2, it would not be inconsistent with the performance of the alleged multi-choice contracts for the NARA to have been used, the particular NARA to have been used for other purposes, rather than being specifically exchanged for US dollars. And the particulars of claim advanced allegations that the particular NARA was subject to quis-closed trust in the hands of the second defendant. We'll see that in section F of the particulars of claim, but that was not pursued before the deputy judge. And so in our submission, the judge could not take the view, should not have taken the view, that the use representation could be necessarily implied in respect of any such multi-choice contracts, because it would be perfectly ordinary for such FX transactions to be dealt with on a contractual debt basis rather than a proprietary basis. And it wasn't averred before the deputy judge that they were on any form of proprietary basis. So we can't rely upon any form of necessary implication. And we also submit in 14 Little Roman 3 of our skeleton argument that the use representation was in fact inconsistent with the factual evidence that was available to the judge in respect of the conduct of the respondent and the second defendant, which did indicate that the respondent and the second defendant worked on a rolling basis of netting off contractual debts rather than accounting for any particular whereabouts of specific monies. And just before I then turn to some of the specific points made in those subparagraphs, I do want to make a few general points in relation to the overall context of these contractual claims, which underpins very large part our approach to this appeal. And I want to do so in circumstances where my learned friend's skeleton argument proceeds on the deceptively simple basis in relation to the underlying contracts, which, as I've said, ad nauseam are matters for trial. Firstly, in paragraphs 43 and 44 of their skeleton argument, if your lordships would turn it up at tab... sorry, forgive me, I think I've got the tab number wrong.
2E?
2E, yes, thank you. And it's at pages 134 to 135. And one sees at the bottom, paragraph 43, they say in practical terms the use representation was made through confirmation that NARA of a certain amount will result in delivery of US dollars. And then they say an example of the earliest such representation from Mr. Mervyn to Mr. Giwa is the following, though this trade was not related to multi-choice. One sees then over the page, cited as an example, a trade confirmation which we accept does contain all the necessary details for a foreign transaction. One has all the relevant amounts, one has identified the exchange rate, one has identified the delivery date, and so on. But that example, as my learned friend Skeleton notes, is nothing to do with any of the contracts that Mr. Giwa is said to enter into on behalf of multi-choice. It's an entirely unrelated trade confirmation.
Do you accept that a trade in that form contains an implicit representation that the NARA there specified will be used to acquire those dollars?
No, we don't. We don't. Because the point I've already made, it's perfectly ordinary for an FX transaction to be dealt with on a contractual debt basis. One can either deal with it in contractual debt terms, or one can deal with it on a sort of trust or proprietary basis. And there were proprietary claims made in the particular claim, but they're not pursued before the deputy judge. And for reasons I'll come on to, when one looks at the reconciliation that the respondent has done, it's plain that the parties were not working on any kind of trust basis, but it was an accounting mechanism going back and forth. But that trade confirmation we would accept identifies the material terms of the contract. One of the key issues here is one doesn't have this in relation to any of the underlying alleged contracts. So the point I want to make, and this is important in relation to the contractual context, because the judge then has to make findings in relation to shortfalls and so on in order to work out whether or not there's been any loss. My learner friends assert that this is an example of the contracts and give the impression that one then has 10 nice, straightforward trade confirmations for the contracts in play here. And indeed, they say in paragraph 44 that a similar exchange happened in relation to each of the multi-choice contracts, sometimes by WhatsApp, sometimes over email, sometimes orally.
So I appreciate you say this is not a multi-choice contract, and these common grounds are not a multi-choice contract. But the proposition, as I understand it, you're arguing for, is that when Mr. Mervyn says that he's going to convert 600,000 Nigerian naira into 1.2 million US dollars, he can do anything with that money.
Provided he on the word convert isn't used in the trade confirmation. It's a trade. In our submission, that's a contract. It's a contract that if I pay you X amount of naira, you will pay me back an agreed amount of US dollars. There's no implicit obligation within that arrangement that you must use the specific naira and convert those specific naira into dollars. And that's relevant in circumstances what Mr. Giwa knew Mr. Mervyn was doing was trading on the market in order to access US dollars to make the payment. But from Mr. Giwa's perspective, it doesn't matter whether Mr. Mervyn has US dollars in a bank account, which he draws on and pays to Mr. Giwa, or whether he takes the naira that comes in and puts it into a cryptocurrency exchange and converts it, and actually one can trace the money. It's not implicit in the trade confirmation that he has to deal with it on a proprietary basis. As long as he honours the contract, that's all that matters. And we do say there's a distinction between contractual debt and proprietary claims in that respect. But the point I want to make here is a more generalised one, that although the impression is given that one has neat trade confirmations reciting all the relevant terms in relation to the underlying contracts for the purposes of the multi-choice contracts, that is not what happened. One never has equivalent trade confirmations for any one of the 10 alleged multi-choice contracts, or indeed for any of their alleged variations. And in fact, if one looks at the particulars of claim, tab 6, page 201.
I think it's tab 6. It is. Sorry.
Oh, sorry, forgive me. Tab
No, it is.
tab 9. I think that's me. Tab 9. Yeah,
Yes, tab
me
9.
being slightly dyslexic with my numbering. I'm sorry. Tab 9, page 201. So one sees at paragraph 23, it's averred that in the course of a year, so September 2020 through to September 2021, multi-choice Nigeria, alternatively Mr. Giwa acting in his own right, and they obviously allege JNFX acting by Mr. Mervyn, enters into a series of contracts reached orally in telephone conversations, and they have evidenced in written communications, including text messages. One then sees the table at the bottom in paragraph 24, where they summarise what they say are the contracts that are entered into. And one sees that there is a total of naira referred to of some 34 billion odd, and the dollar sum is said to agree to have been transferred as 74.5 million US dollars. But if one then goes to page 204, one sees what Mr. Giwa says happens in practice at paragraph 28. So he says on various occasions, so he says JNFX, we would say Mr. Mervyn was unable to complete the exchange of the total agreed sums in dollars and so refunded with Mr. Giwa's agreement the relevant naira back to Mr. Giwa. Mr. Giwa thereafter sourced dollars for multi-choice Nigeria in exchange for those naira with alternative currency exchange providers. Is the quantum of dollars to be exchanged under the various multi-choice contracts were accordingly reduced by way of a variation of those contracts commensurately with the naira so refunded. Mr. Giwa has at the present time been able to specifically trace naira sums which were so refunded in the sum that's there identified for traced naira. It goes on, it says, however, and whilst Mr. Giwa is continuing to seek to finalise the position, he accepts they're likely to have returned more naira than the traced naira. His present best recollection is that the total sum of such unpresently untraced naira returned to his companies in relation to the relevant transactions was, and then again there's a figure identified. And he says they come to 8,361,000,000 odd, for which he says Mr. Giwa gives credit, such that the quantum of dollars to be exchanged under various contracts is reduced by a sum commensurate with the overall figure by way of variation. And then one has the revised table at paragraph 29. Of what they say the contracts as variously varied orally result in being. And then one sees the table at paragraph 30, where the respondent sets out what he says are all the particular alleged defaults. I use that word default loosely because as I'll come on to, some are in fact said to be overpayments, and one can see there's been a change by reference to the amendments in the respondent's position in relation to those numbers. But just to be clear, there is no neat and comprehensive suite of emails akin to the unrelated trade confirmation that my learned friends cite in their skeleton argument. Instead, we address this in paragraph 36 of our skeleton argument, what the respondent relies on to explain these figures in paragraphs 29 and 30 is an 87-paragraph schedule headed Reconciliation Narrative, which was appended as a schedule to the first affidavit of the respondent when he sought a worldwide freezing order against other defendants, but not JNFX. And that reconciliation narrative itself is then accompanied by two substantial and somewhat complicated tables. And notably, Mr. Giwa explains in that narrative, which I'll take the lordships to in a moment, but he explains in that narrative that he cannot find records, all separately recalled, the asserted agreed rates of exchange, which he claims he's worked out, in relation to the first contract, see paragraph 8 of the narrative, the second contract, see paragraph 10, the fourth contract, see paragraph 14, the seventh contract, see paragraph 48, and the eighth contract, see paragraph 54. So in relation to all those contracts, he's worked out what he believes the exchange rate is. He says he's calculated it. And even in respect of the other rates, which he says he believes or believes likely applied, so in relation to the third, the fifth, the sixth, and the ninth contract, he again says he doesn't refer to any records to support those calculations. And the full scale of the complexity of the calculations which the respondent seeks to rely upon, and all the various suppositions and assertions which he seeks to justify that are not evidenced by documents, is only really apparent from a full reading of the reconciliation narrative. And of course, it's a narrative that Mr. Giwa has not yet been cross-examined on, and it's a narrative he will be cross-examined on in the trial of the contractual claims. If I show your lordships that narrative document, that's in the supplementary bundle behind tab 6A. So 6A is the first affidavit of Mr. Giwa that was relied upon in support of the claim for worldwide freezing relief against, I think, the fourth defendant. And Schedules 1 and 2. So Schedule 1 is at page 191 to 193, which sets out various computations which have resulted in what Mr. Giwa says the various figures are. But the reconciliation narrative itself at page 194, and this is the extensive document in which he seeks to work through what it is said the various contractual arrangements were as varied and where one ends up in relation to calculation of what he says is due. And if I just ask your lordships to read paragraphs 1 through to 3 of that document so you understand the context in which it's pulled together. So in relation to the asserted use representation, see there that the respondent said himself that the exercise of reconciling all the payments between MultiChoice and JNFX, pausing there to remind your lordships that a lot of these payments don't actually come to or from JNFX, has been extremely difficult, intricate and time-consuming, apparently taking some 4 months with the assistance from his solicitors. The fact that it takes him 4 months with the assistance from his solicitors in order to produce this is relevant insofar as our client ought to be given a proper opportunity to consider it in the fullness of time. And he makes that narrative, he's produced that narrative in circumstances where he says, on his own case, that transfers in bank statements do not provide references such that a payment can be linked to a particular order, and that notes that he was processing transactions with Mr. Mervyn not just on behalf of MultiChoice but with other clients, and that a reconciliation process had to be undertaken between them to take stock of transactions completed in that period, and that he himself is unable to trace the origin of certain US dollar payments that are made to MultiChoice. All of that in our submission suggests that there was no expectation of a specific conversion of particular naira into US dollars. The relationship was one based in contractual debt. I'm being reminded by my learned juniors that we have transcribers remotely, and that I need to, subject to the court, afford them a very short break.
I'm afraid the practice in this court, and I know it's a burden on the transcribers, but the practice on this court is not to give them a break.
So be it. I'll continue.
Are we going to get copies of the transcript?
I'm afraid until 10:29 this morning I didn't know there was a transcript, but I'm sure that could be arranged. I don't know who's arranged for it, but I'm sure if the court asks, the court will get.
Thank you.
We'll treat that as a request.
Yes, please.
Can I just say, for future reference, that if a transcription is being paid for, it is useful to tell the court at the outset of the appeal.
Yes, I mean,
because it affects the detail of the notes which we choose to take.
not only that, if you look at the rules, you will find that there is a requirement you obtain authorisation. And in this court, it goes to the presider, and I've had no such request for authorisation. I'm not going to take
No,
a point.
I know. All I was going to say in defence of those behind me, I don't believe it was our request for the transcription. As I say, I didn't know until this morning. But there it is, and I'm sure it will be made available in any event, whoever has attained it. And I just apologise on behalf of all of us for the absence of the formal request. and again, just working through the use representation and why we say it's contrary to the evidence of what happened. If one looks within the same tab, do the same narrative, if one jumps to page 207 to 208, one sees here paragraph 43. Mr. Giwa is explaining that in fact he doesn't even transfer the full amount of Naira in relation to the alleged sixth multi-choice contract. What sees that at the bottom of page 207, he says the US dollar value for the NGN was approximately $9,813,857. I believe Mr. Mervyn may have owed me in relation to a separate transaction around this time, and as a result I did not transfer the full Naira amount for $10 million as part of the continuous process of netting off between us. Moving on then to paragraph 69 of this narrative, and actually before I get there, sorry, if I can go to page 211, I'll just ask your Lordships to take note of paragraphs 55 through to 56, which rather deftly demonstrate the complexity of working out what the supposed shortfall, whether in Naira or US dollars, really is. And this is in relation to the 7th and 8th contracts. If one goes then to paragraph 69 of the schedule at page 215, one sees in relation to the alleged 9th contract, Mr. Giwa says he doesn't begin transferring Naira to Frontier Nigeria until the 1st of June for a number of reasons. And importantly, one of those reasons, that's 6 lines down within that paragraph, is that he says he wants Mr. Mervyn to build up a large enough position in liquid currencies sufficient to deliver the US dollar bulk payment as agreed. So in that instance, he's not looking at Mr. Mervyn taking the money, trading it, converting it and returning it. Rather, he wants Mr. Mervyn to have access to the dollars prior to any transfers of Naira. We then make reference within our skeleton argument to 2 particular WhatsApp exchanges, which we say further undermine the suggestion that the use representation was either made or could be implied from circumstances, but bearing in mind at the time, I'm not going to turn up those individual WhatsApp exchanges. We've made points in the skeleton argument. And in circumstances where what Mr. Mervyn did or did not say are not matters within JNFX's knowledge, JNFX, as I've already mentioned, has quite properly required the respondent to prove his case in relation to the content of those tables that are in paragraphs 38 and 39 of the particulars of claim. So to prove his case in relation to how it says these contracts are entered into, what are the relevant figures, what are the exchange rates, what's the computation, how does one account for refunds in circumstances where Mr. Giwa is already saying it's all very difficult and it's his best guess at present. And in that respect, we do say it was reasonable to believe that a fuller investigation of the facts in the ordinary course of litigation, including disclosure from the respondent, disclosure from multi-choice, disclosure potentially from third-party recipients of the Naira in circumstances where it isn't received by JNFX, and or oral evidence from the respondent based on his reconciliation narrative, tested by cross-examination, going to the underlying documents, it was reasonable to believe that that process could add to or alter the evidence available to the trial judge. And indeed, the deputy judge failed to take account of the fact that all that evidence would be available to the trial judge in the context of the contractual claims in due course in any event. And the burden of proof point I've already made, but we do draw attention to the fact that the phraseology of the judgment is that he's not persuaded that there was any substance in JNFX's assertion that it had a realistic prospect of showing that the use representation was not made. The finding that the judge should have made.
Where does he say that?
Sorry. Paragraph 16. Sorry, forgive me. Yeah, paragraph 16. So core bundle tab 5, page 169 over to 170. And one sees the point I've just made at the very top of page 170. JNFX asserts with the benefit of further disclosure and cross-examination of Mr. Giwa, there has to be a realistic prospect of showing the representations were not made, but I'm not persuaded there's any substance in that assertion. So he seems to take as read the representations and work out whether or not JNFX is likely to be able to disprove them, rather than making positive findings in relation to how they're made. But the point of substance in our submission remains the same. That brings me to the second ground of appeal, namely that the judge erred in finding that JNFX had no realistic prospect of showing that the representations, so both of the representations, if made, were not false, and again that no reasonable grounds existed for believing a fuller investigation into the facts would add to or alter the evidence available to the trial judge on that issue. And we also make that point in the alternative by reference to the first 9 contracts, if the court's not with us in relation to the submission, in relation to all of the contracts, because my learner friend, due course, will say that there's a distinction to be drawn between the 10th contract and the previous contracts, but the deputy judge makes the finding that we say he shouldn't have made in relation to all of the contracts. And again, just to be clear, I've highlighted the material elements of the tort of deceit, but the point in time at which the representation has to be false is the time at which it's relied upon. It doesn't matter what happens after the relevant area are transferred by Mr. Giwa. The representations have to be false at the point in time that they are relied upon. And we make the obvious point in paragraph 17 of our skeleton argument that whilst the standard of proof plainly doesn't vary with the gravity of misconduct alleged, the court should have regard to inherent probabilities. And as a matter of common sense and broad generalisation, it's inherently less likely that a person will be dishonest rather than incompetent. And again, the obvious point that where fraud is alleged, cogent evidence is needed to prove it, in order to address the inherent improbability that people act dishonestly. That isn't in dispute, so I'm not going to take your lordships to the Food Co judgment of Mr. Justice Lewis, and as he then was. Paragraph 3 is obviously the relevant paragraph, and it's in the authorities bundle at tab 4. And at paragraph 16 of the judgment, your lordships will see that the deputy judge makes the stark finding, is at page 169 of the core bundle, that there was no evidence in the present case to suggest that Mr. Mervyn did not, at the time he made the representations, have the attention alleged, and there was no real prospect of such evidence being obtained. Just unpacking that, when he says have the intent that Mr. Mervyn did not, at the time he made the representations, have the intention alleged, he means that the second defendant intended not to act in accordance with the representations. It's a slightly unfortunate way that it's been phrased. But effectively, he is saying that there's no evidence that they're not false. And in our submission, in reaching that conclusion that there's no evidence that they're not false, over the course of paragraphs 17 through to 28, the Deputy Judge wrongly conducted a mini-trial of the evidence, and also failed to take account not only of the contrary evidence which was before him, having wrongly said that there's no evidence, but also that reasonable grounds did exist for believing a fuller investigation might add to or alter the evidence available to a trial judge, bearing in mind these contractual claims were going to trial. We make a number of points on this ground in our skeleton argument, and first and foremost is the obvious one, paragraph 18 of our skeleton, that even on the respondent's own case, there had been substantial due performance of the alleged multi-choice contracts. And one sees that from the tables within particulars of claim at paragraphs 29 and 30. Of the $60,408,000 US, which it's alleged the second defendant represented he intended to procure the payment of to multi-choice, on the respondent's case, payments totaling in excess of $44 million US were in fact made. And at the very least, in our submission, that is some evidence that the representations, if they were made, were not false at the time that they were made. And taking the other points in turn, which we've grouped within paragraph 19 of our skeleton argument, and bearing in mind that a number of these points we say are also relevant to other grounds of appeal, I'm going to refer to them, if I may, as our paragraph 19 points, but take the court through them now. Firstly, if one turns to the tables within the particulars of claim, page 201, tab 9 in the core bundle, as the tables I showed your lordships earlier. Sorry, that's a miss. Sorry, page 201. One sees the contracts there as varied. The contracts are then at page 205 in paragraph 29. And then in paragraph 30, one sees the respondent's case in relation to the alleged breach. And on the defendant's own case, one sees, in respect of the third and fourth contracts, there is an alleged overpayment. So not only fully performed, but more money is provided. They then allege that there's a breach in respect of the fifth contract, but one can readily see from the numbers there that if one applies the overpayment in respect of the third and fourth contracts to the alleged shortfall in respect of the fifth contract, there's no shortfall. There's then no alleged shortfall in relation to the sixth contract. Instead, there's an alleged overpayment. And notably, that is despite the fact that in the evidence I took your lordships to in paragraph 43 of the reconciliation narrative, Mr. Giwa explained that he did not transfer the full naira for what he contends was the originally agreed amount as part of the continuous process of netting off. So one sees full performance despite the fact that Mr. Giwa hasn't even handed over all the relevant naira. In addition, the point we make in Little Roma 4 is again based on the respondent's own evidence. And if one looks back in the reconciliation narrative, sorry, it's the supplementary bundle at 6A, page 206. And this is in respect of what was then claimed to be a shortfall. And sees at paragraph 40, it was then claimed to be a shortfall of $1,208,000. But by the time one gets to the particulars of claim, that figure has come down. This is in relation to the 5th contract. It said in the particulars that the shortfall is in fact only 708,000. So there's been a movement in that respect. But even in relation to the then perceived higher shortfall of just over $1.2 million, Mr. Giwa himself says, in regard to that shortfall in this order, generally, shortfalls in deliveries by JNFX were not considered a particularly concerning problem because everyone appreciated the difficulties of sourcing US dollars with Naira, and there was an expectation that the shortfalls would be made up for with overpayments on subsequent orders. And going over the page, continuing the same point at the top of page 207, Mr. Giwa's evidence is that even when the gap was reaching what he believed to be $5 million during the delivery of the 8th order, he says it was not perceived to be of particular concern by MultiChoice, especially given the economic environment of the constantly devaluing Naira, where the same or worse losses can be caused by simply holding on to Naira. So again, in our submission, that undermines the inference of falsity, and on any view it can't be said that there's no evidence that undermines it. Then in respect of the particular shortfalls alleged in respect of the 8th and 9th multi-choice contracts, this is the point we're making in Roman 6 of paragraph 19. Looking back at the table, the shortfalls alleged of $900,000 out of a total of $8.1 million in respect of the 8th contract, and a shortfall alleged of $1 million out of a $10 million amount in respect of the 9th alleged contract, taking those figures directly from the tables. Those are shortfalls of just over 11% in respect of the 8th contract and less than 10% in respect of the 9th contract. And in our submission, bearing in mind what Mr. Giwa has said about the difficulties of exchange and the devaluation of Naira, they were plainly capable of being attributable to such constantly devaluing Naira, do not give rise to an inference of fraud. Moreover, in relation to the 9th contract, again going back to what Mr. Giwa said in his reconciliation narrative, it's page 216 of the supplementary bundle. And paragraph 73 at the bottom of page 216, he claims that Mr. Mervyn and I agreed that I would transfer $4,247,000,000 Naira in the expectation of $10,000 being delivered to MultiChoice by the 9th of June 2021. I believe the rate we'd agreed upon was likely 482 Naira, and at this rate the dollar value is 8,867,219. However, Mr. Mervyn had agreed JNFX would deliver $10 million. This has been due in part to the outstanding sums owed by MultiChoice that had begun to build, also due to the netting off process. But in any event, what he is saying is that less than the amount of relevant Naira has been transferred than is required to deliver the agreed amount of US dollars. And the difference the shortfall that's alleged in respect of that contract of $1 million is less than the difference between the 10 million and the asserted value of the Naira that it said has been transferred. So there isn't a shortfall by reference to the amount of naira that's been transferred. So again, that cannot be said, or indeed it must be said, that undermines the inference in relation to falsity of the representations. In then Roman numeral 8, we make the point that given the substantial difficulties Mr. Giwa claims to have experienced in conducting his own extremely time-consuming reconciliation exercise, there was every reason to believe, and indeed the judge rightly held at paragraph 19, that Mr. Giwa's reconciliation, and these are the words of the judge, is not perfect, and there may be room for argument about the precise form of the shortfall, sorry, the precise amount of the shortfall. That's at paragraph 19 of the judgment. So the judge is accepting that the figures are not definitive. We also make some points in little Roman numeral 9, some timing points based on the respondent's own evidence. And that in order to calculate the shortfalls he's alleged, we say Mr. Giwa's applied a purportedly contract by contract analysis, which it isn't clear is appropriate. So the points there made, firstly, that the respondent contends that there's a 708 million shortfall in respect of the fifth contract, which is said to have been agreed on the 17th of December 2020. But in February 2021, a total of $4 million is then said to have been received. But Mr. Giwa says that later receipt is not in respect of what he says the shortfall is on the fifth contract. He says it's performance of the sixth contract, arguably inappropriate. Similar point in relation to the seventh contract, where shortfalls are alleged. But if one looks at payments that come in subsequently that Mr. Giwa says are for subsequent contracts, there wouldn't be a shortfall. Same again in relation to the eighth contract. As to how the judge concludes that nevertheless there's no evidence to suggest that they weren't false, that paragraph 17 of the judgment, I should take your lordships to that, sorry, this is where we say the judge has effectively conducted a mini trial on the evidence before him. Page 170 of the core bundle. The judge notes that the grounds on which Mr. Giwa alleges it's to be inferred that the use and payment representations were false are set out in 9 subparagraphs of paragraph 41 of the particulars of claim. And then what the judge does is to work through those, not taking into account any of the points that we've made. We have addressed these in paragraph 20 of our skeleton argument. So firstly, the judge refers to paragraphs 41 and 42 of the particulars of claim. There, Mr. Giwa had made the point that naira deposited in the account had not been used. Sorry, forgive me, I ought to do, if I take your lordships, the paragraphs themselves in the particulars of claim, so your lordships have the reference. Paragraph 41 begins at page 209. One see, the easiest way of seeing it. Paragraphs 41 and 41.2, the points there relied on by way of inference were that sums hadn't been used to exchange for dollars, and a failure to procure payment in respect of the 10th contract. There, the Deputy Judge at paragraph 18 rightly says that those are matters that of themselves don't evidence falsity. But he then wrongly concluded, without analysis, at the end of paragraph 18, that he was unable to accept Mr. Elam's alternative explanation was the more plausible explanation, or that it was an explanation that would of a real prospect of being upheld at trial. Just to be clear, the alternative explanation which was advanced and which was consistent with all the matters we've raised in paragraph 19 of our skeleton argument to address your lordships in relation to, was that it's perfectly possible that the second defendant had only subsequently got into difficulties in relation to the depreciation of Naira, and that was an explanation for what had happened. It wasn't an obvious inference that the shortfalls, insofar as they could be established, should result in an inference of falsity. And where the judge says that he's unable to accept Mr. Elam's alternative explanation, we respectfully submit that the judge does ask himself the wrong question. The burden was not on JNFX to establish that the alternative explanation was the true position. The burden is on Mr. Giwa to establish that the representations were false. And instead, what the deputy judge appears to have done is to work out whether or not JNFX would succeed in proving that there was an alternative explanation, which in our submission is looking at the question the wrong way round, because insofar as there was any alternative plausible explanation that gives rise to real doubt as to whether the representations were false, then obviously such doubt weighs against the prospects of Mr. Giwa proving falsity. And the judge simply shouldn't have found that there was no evidence that they weren't false. If I move then to paragraph 41.3 of the particulars of claim, this is addressed by the Deputy Judge in paragraph 19. And this is an inference sought to be drawn from what are said to be multiple seven-figure dollar shortfalls across the contracts. But I've already made a number of submissions in relation to the difficulty in any findings in relation to the particular quantum and timing of those purported shortfalls. And of course, the computation and timing of those various shortfalls is a matter for the trial of the contractual claims. Paragraph 19, the judge notes that JNFX had argued that the analysis performed by Mr. Giwa was not sufficiently robust for the purposes of the allegation. And that's where the Deputy Judge says he accepts the reconciliation is not perfect, that there may be room for argument about precise amount of shortfall, but he goes on to say, without explanation, that he says it cannot realistically be demonstrated that there were not substantial shortfalls, or that the existence of those shortfalls does not support the inference of the falsity of the representations. But he doesn't go through the contracts to identify how those shortfalls come into existence. Moreover, for the reasons that we've already advanced, those shortfalls in and of themselves, in our submission, don't support the inference of falsity for the reasons we've identified, or at the very least there's a real prospect that Mr. Giwa wouldn't establish that at trial. So in essence, we say the judge should have concluded that there was a real prospect of JNFX successfully defending the deceit claim at trial on that point, namely that the representations were not false, because no reliance, or certainly no definitive reliance in finding falsity, should have been placed on any asserted computation of shortfalls without analysis. Paragraph 20 of the judgment, the judge then deals with paragraph 41.4. And here, Mr. Giwa sought to rely upon what was allegedly said during a meeting on the 17th of January 2022 by directors of JNFX to representatives of MultiChoice. But that meeting post-dates the alleged 10th contract, and it post-dates all the relevant transfers averred by the respondent by more than 4 months. So in our submission, it's difficult to see how any inference of falsity could be drawn from what might have been said by persons other than the second defendant at that subsequent meeting. And in addition, the deputy judge rejected JNFX's position that what was said at that meeting was equally consistent with the possibility that Mr. Mervyn may have been trying to trade out of the difficulties that he'd got into. And he rejected that submission, obviously without hearing any evidence from any of the persons who were there at that meeting. And he says in the final sentence of paragraph 20, he says he's already expressed the view that he doesn't consider the alternative explanation to have any real prospect of success. So he's already decided that the alternative explanation is implausible, and that causes him to reject what's said in relation to that meeting, but without the possibility of hearing from any of the witnesses in relation to what was actually said at that meeting, even if it was relevant, bearing in mind it's so much further down the line. And on any view, what he should not have done is to make any findings in relation to, which were in fact assumptions, in relation to the director's intentions in relation to what was said without hearing from them. Paragraph 41.5 of the particulars of claim addressed a skeleton argument which had been filed by the respondent in relation to a winding up petition, and Mr. Giwa sought to rely upon a submission in that skeleton argument as supporting the inference of falsity, but the deputy judge correctly found that that was not in any way determinative of whether the alleged representations were false at the time. That's in paragraph 21 of the judgment, so he discounts that, but repeats reference to the alternative explanation, comments that there was no hint of it, but he doesn't indicate whether or not that informs his ultimate view, and one has to take it that his considered position is that that skeleton does not advance matters at all. Again, paragraph 22, where the judge deals with the matters referred to in 41.6 of the particulars of claim. Again, the judge finds that they don't advance Mr. Giwa's case on falsity, so he's not relying on those either in order to make finding of falsity. And then goes to paragraph 23, where the judge deals with paragraph 41.7, where Mr. Giwa sought to rely upon alleged separate representations by the second defendant after due dates for payment. And the deputy judge says in 23, third line down, that in isolation, these matters could be viewed as consistent with Mr. Mervyn's intentions when the representations were made not being false. So on the face of it, they're not inconsistent with the alternative perfectly plausible explanation, so it's not obvious that the inference of falsity should be drawn. But he says, in light of the totality of the evidence relied upon Mr. Giwa, in his judgment, that's not a realistic alternative explanation. So in saying in light of the totality of the evidence, he's obviously got in his head his evaluation of various evidence, which we say is falling into the trap of a mini trial. It's not apparent, though, what the totality of that evidence was that he has in mind. In the relevant paragraph of the particulars of claim, 41.7, one sees that at page 210, it's a simple averral that after the due dates for payment of the full dollar sums under the contracts had passed, it said Mr. Mervyn represented on multiple occasions, and then 4 specific dates are given, that he intended to procure the payment but failed to do so. But if one takes those 4 dates, it is only on an arguably inappropriate contract by contract analysis that one can say payment isn't procured. So one gets back into the analysis of the chronology of payments and what the actual shortfalls are. And my learned junior made the submission that was obviously something that needed to be dealt with at trial by reference to the relevant documents that were being sought to be relied upon. And even insofar as it was being said that on numerous occasions Mr. Mervyn had provided Telex's confirmations which it was claimed were false, Mr. Giwa, again on his own evidence, accepted that sometimes what he thought were false payments nevertheless came through. I'll just take your logic to what we say in our skeleton argument about that point, because I'm afraid it's a little bit intricate. But we say that this So these are the submissions that we make, paragraph 108 to 109 in our skeleton argument. Sorry, page 108, did I say paragraph? Apologies. And this is in relation to the finding by the judge at paragraph 25 in response to Learned Junior's submission that these were matters, so allegations in relation to falsity of documents and what had been said in terms of when payments would be made and what would had come through and not. My Learned Junior had said it was obviously something to be proved at trial by reference to the relevant documents, and the deputy judge says, in my judgment, there's ample evidence to show that the confirmations which Mr. Giwa was provided did not reflect the true position. But he doesn't in the judgment go through how he reaches that conclusion. But even assuming that that's a conclusion that he's done by an evaluation of the evidence, that in our submission is wrongly conducting a mini-trial in circumstances where Mr. Giwa had been required to prove his case, both that any confirmations that were said to be false were false, and in relation to any allegations of inauthenticity. But even in respect...
So just trying to understand how that works, because Mr. Giwa's evidence is that the SWIFT messages are false. So what's the judge supposed to be doing? Because there's no evidence to the contrary. There's no evidence that they're authentic. So the judge is... I appreciate your point is he's not to conduct a mini-trial. But is there reasonable grounds in your submission for supposing that evidence of authenticity will turn up?
Well, can I just take that in stages, if I may? The judge appears to be placing some reliance on what are said to be fake SWIFT messages as somehow supporting an inference of falsity in relation to separate representations. The respondent says that one can't assume that confirmations which are said to be false are false. The judge doesn't go through them anyway, but also the point I want to show your lordship is that on Mr. Giwa's own evidence, he says there are a number of occasions when even when he suspects he's being provided with fake SWIFT confirmations. Money still comes through. And in our submission, that feeds into the more general point that one needed to have a careful analysis of what ultimately is a question of quantum in relation to, well, not only terms, but also quantum in relation to the underlying contracts before one can even get into working out what's fake, and even if it's not real, what does it support? And instead one sees just the statement by the judge that there's ample evidence to suggest they don't reflect the true position.
So, those may all be good points, but I'm not sure they're an answer to my question. My question was, there's unchallenged evidence from Mr. Giwa that these are false. There's no evidence that they're authentic. What's the likelihood of evidence becoming available to show that they are authentic?
Insofar as it would feed into the analysis of what payments come in and what payments don't. The problem with, I appreciate I'm skirting around the edges, but I'm not saying, or we're not saying that evidence will come from someone necessarily saying, oh, well, actually, these are genuine. But the appellant ought to be afforded the opportunity to work through it all, to work out how it all fits in together. And even
So you're not saying that there's likely to be evidence that they're genuine. And then that leads on to the next question, is why does an honest trader produce fake SWIFT messages? It's a little hard to see any explanation for that.
But can I take your logic to what Mr. Giwa says? Paragraph 26 of his reconciliation narrative. Sorry, I've got the wrong paragraph reference. It's 74. I think I need to unpack slightly. It's not that we are not saying that there's going to be evidence that particular transactions, which may or may not be said are fake, were genuine. The point we're making is that the judge was wrong to make the finding that they were fake. He doesn't explain in the judgment how he gets there. So what we've sought to do in the skeleton argument is to unpack how the judge got there by reference to the submissions that were made by Mr. Giwa in relation to what it has said in relation to fake transactions. And then...
Well, as I say, at the moment I'm struggling to understand that submission because... And appreciate this is a summary of a slightly more nuanced position, but in essence, there is unchallenged evidence from Mr. Giwa saying there's fake SWIFT confirmations. And the question then is, well, there's no evidence as you accept that they're genuine. And then the question you say, and very fairly, is, well, that's not the end of the story, because the court has to ask itself, is there a reasonable possibility of further evidence becoming available at trial? And in the abstract, that may be so, but the question I'm asking is, well, how so? How is it likely, or even possible, that evidence of authenticity is going to become available? And your initial answer to that was you weren't saying that such evidence would become available, and that then led on to the next question is, well, why does an honest trader provide fake SWIFT confirmation messages? And you were then going to refer to me to what Mr. Giwa had said on that question. So if you want to go back on your answer on the first question, by all means do, but I'm still struggling to understand how, if evidence is genuine, that the messages are authentic is not available now, it's likely to become available.
Where I need to backtrack is to not even get to that question in the first place, because our submission is that the judge shouldn't have made findings that they were fake based on the submissions that were being advanced and the documents that he was being shown, because in order to conclude that they were fake, one needed to consider them in the context of the movement of funds and work out what matched and what didn't. And the reason we say that is that Mr. Giwa, in his own evidence, and forgive me, that's the paragraph I'm struggling to find, and I may need to pick up that paragraph after the lunchtime adjournment to take your lordships to it, but Mr. Giwa himself had said that there were instances where he had thought that confirmations were fake, but in fact the monies had come through. So I'm grateful to my learned junior who's found the relevant paragraph that I was struggling to find on my feet, which is at page 167 of the supplementary bundle within Mr. Giwa's first affidavit. So this is not within the reconciliation narrative, it's within the covering affidavit, which I think is why I was looking in the wrong place. But page 167, he there says that there are a number of occasions when he suspected Mr. Mervyn was providing fake confirmations and that he challenged him on, sorry, forgive me, page 167. So Mr. Giwa's evidence, he says, there are a number of occasions from as early as 23rd of December when I suspected Mr. Mervyn was providing fake SWIFT confirmations of payments and challenged him on this. However, at the time I understood these to be delayed tactics, and ultimately some of the suspicious confirmations would clear. And others would be replaced by different payments coming through later, and I certainly did not suspect at the time that Mr. Mervyn was misappropriating funds.
Fine, but that's evidence that Mr. Giwa suspected that other confirmations were fake, which proved not to be. How does that help with the ones which he says are fake?
Well, in our submission, the judge was wrong to say that Mr. Giwa details numerous occasions when Mr. Mervyn sent fake payment confirmations. So in our submission, that's not accurate. And the point we then make is in circumstances where the respondent himself is saying that, and in fact, some of them clear anyway, one doesn't have clear, or the judge didn't have before him, clear evidence that they were fake. So the point we're making is the judge should just not have decided that there were numerous occasions when Mr. Mervyn had sent fake payment conversations. Didn't have that evidence before him.
Well, that's a much more simple submission. If your submission is there's no evidence they're fake in the first place, then fine.
Yeah, I apologise if I'm inadvertently overcomplicating it, but the difficulty is the judge in the judgment doesn't detail the evidence he's supposedly relying upon. He just says there's ample evidence to show they don't reflect the true position, and we have no unpacking of that. And in our submission, that's not a finding that should have been made.
Yes, but as I understand the submission you've just made, it's a very straightforward submission, which is we have a pleaded allegation in paragraph 41.8 of the particular claim. The SWIFT confirmations referred to are false, and your submission is that's a pleaded allegation that's not supported by evidence. And that's a submission I can understand.
But and that submission, which your lordship's just indicated is an understandable submission, is this a submission that we seek to substantiate at the bottom of page 14 of our skeleton argument by reference to the documents that we are referred to. I'm going to move on. I may just come back to that point after lunch on the agenda. I don't want to make use of the time. I'm going to move on to paragraph 41.9 of the particulars of claim, if I may. And this is addressed by the judge in paragraph 26. And this is where reliance is placed by Mr. Giwa on a WhatsApp message, which is cited within paragraph 6 of the judgment at page 171. At the terms of which your lordships will see. Our submission is that WhatsApp message obviously doesn't specify what these lies are a reference to, and that it can't be inferred just on the face of it that it's a specific reference to the representations. it is what it is, but what's important is that the judge should have made findings in relation to falsity as at the time that they are relied upon, and that WhatsApp message also comes after the last payment of Naira. All of that in our submission feeds into the fact that we say the judge was wrong to conclude at paragraph 28 that he was not persuaded that JNFX had a realistic prospect of defending the deceit claim against Mr. Mervyn on the basis that there was no realistic prospect that Mr. Giwa would be unable to prove at trial that the alleged representations were false, and there was no conflict of fact or reasonable grounds which existed for believing that a fuller investigation into the facts would add to or alter the evidence available to the trial judge. I've already made the point that not only would the trial judge have made findings of fact based on all the then available evidence, including in relation to what's said in relation to various confirmations and so on, but the trial judge would then make findings of fact in relation to the actual shortfalls in US dollars, and in circumstances where there was and is a plainly alternative, plausible explanation for what happened. So it wasn't appropriate for the judge to conclude that the only inference was that these representations were false. And insofar as we say relevant further evidence might come to light, one has the point in relation to the lack of evidence in relation to what happens in relation to the money that comes into the account, the Naira that comes into the accounts operated by the second defendant. The submission was made below that there's every possibility that insofar as there are shortfalls, brackets those shortfalls not yet having properly established, plainly capable of being explained by reference to what happens in relation to movements of money, cryptocurrency exchanges, and so on. And it's well known that cryptocurrencies are, of course, volatile, and Mr. Giwa himself has said that there's problems in relation to devaluation of Naira and so on. But on any view, it's only once one has that full picture of all the evidence available that one could and should make a proper determination as to whether or not an inference of fraud would be the right one.
Can you explain to me how that works with the 10th contract when nothing was paid? The difficulty is that Mr. Mervyn takes the Naira, buys cryptocurrency, and it devalues before you can change it into dollars and so on. I wouldn't have expected it to produce nothing. Or at any rate, if it had, one would expect that to be a notorious event if some particular cryptocurrency had devalued to nothing. So how does it work? And what is your alternative theory?
Well, I come back to the starting proposition that it's for Mr. Giwa to prove falsity at the time that the representations are relied upon.
I understand that, but if someone says to me, yep, you give me 4 million Naira,
yes,
I'll 4 billion Naira, I'll give you $10 million.
Yes.
I transfer the 4 billion Naira and nothing. No explanation, but just nothing. It's quite difficult to avoid the inference that when he said, I'll give you $10 million, he didn't mean it. That's the simplicity of the case on the 10th contract.
In relation to the 10th contract, which I accept has to be looked at in the alternative in isolation, here the judge looked at all of them together and makes conclusions along the way.
Yes.
But if one then looks at the 10th contract in isolation, the date, and in our submission the dates are material, the date on which the Naira are transferred to accounts operated by Mr. Giwa by the respondent, taking them from page 232, the particulars, the dates of those transfers, 3 tranches, 8th of September 2021, 16th of September 2021, and the 22nd of September 2021.
Yes.
Obviously, the default, assuming the terms of the contract are established and whatever the relevant amount of the default is, but the default is subsequent to that. And what's important is not, well, it's relevant as to when Mr. Mervyn has an intention which causes the representation to be false.
So he might have intended to comply with the contract when he
receives the money.
When he receives the money, and then later decided to steal it. That's
yes. Yes.
That's the...
Well, yes. I mean, we say there is an alternative, plausible explanation which gets into difficulty, and then, I mean, in a sense, Bearings is the obvious example of that. It all got too much to Nick Leeson, and then one stops where one ends. And for the claim in deceit to work, as distinct from the contractual claim, and bearing in mind that just because the deceit claim might fail, it doesn't mean that Mr. Giwa is left without a remedy. It just means that it's a question of contract, and that contractual claim will be determined at trial. So saying that there's no valid deceit claim because there's no reliance on a representation which is false at the time of the reliance does not deprive anyone of any remedy, because there's a contractual claim.
But I mean, I understand that the deceit claim depends upon showing that the representations were false at the latest when they were acted upon.
Yes.
But when one stands back from it, you know, a very common form of deceit is someone goes into a restaurant, orders a meal, eats the meal, and then walks out without payment. Now that's a deceit because, of course, in theory they could have intended to pay for it when they went in and changed their mind after they've eaten. But in practice, that's a bit unrealistic, and it's a bit like that, isn't it?
Well, in our submission, no, because, and this is where I come to our application to produce new evidence, because what we say that new evidence shows, if I just address you on it to Benny for a moment and then come back to the threshold test for admitting it, but we say that that new evidence shows Mr. Mervyn complying with a separate contract, exchanging Naira for US dollars, with another of Mr. Giwa's clients as late as the 21st of September 2021. So that only leaves one tranche of the three tranches that are related to the 10th contract that comes after that, indeed the day after it. On the evidence, we say one sees Mr. Mervyn complying, in effect, with contractual obligations to Mr. Giwa, such that there is a valid argument that it's only later that he does a run or whatever with the money wherever it goes. We don't yet know the answer to that. And indeed, without going through that evidence just yet, Mr. Giwa accepts that that new evidence does indeed show Mr. Mervyn providing US dollars for another of Mr. Giwa's clients on the 21st of September. So right up until that point in time, one has compliance with the contracts.
So it's a defence to the allegation of theft from A that you didn't steal from B?
No, because we're not saying any of this would be a defence to an allegation of theft. We are saying that this goes to whether or not the judge should have found as a fact, on the basis that it couldn't possibly be considered to not be the case, that the representation at the time it was made was false. And it's an entirely separate question about whether and if so what liability there is under contract. Once the court has gone through various contractual claims, dealt with the illegality point and so on. It's purely focused on the deceit claim and reliance upon the relevant representations, and the representation must be false at the time it's supposedly relied upon. Now, Mr. Giwa says these representations were false from the outset. And indeed, that seems to be what the Deputy Judge found. But in fact, as I've shown your Lordships, from the outset, they're not false, because one has compliance with the contractual arrangements as one goes along. So, taking Mr. Giwa's position that, and looking at the 10th contract in isolation, one is saying, well, there's something gone wrong, he's stolen the money, whatever. One still has to conclude that at the time the representations of compliance were made, that intention of dishonesty subsisted, rather than it being a subsequent dishonest intention at the point in time later on when he decides he's not going to honour the contract. And I say it doesn't mean that there's no claim in respect of any default on that 10th contract, but it means that's a contractual claim, it's not a deceit claim. And now, my learned friends in their skeleton argument seem to suggest it doesn't matter when the dishonest intention arises, but in our submission it is crucial, because the reliance has to be on the false representation. And it's for Mr. Giwa to establish that the representation was false at the material time. They allege it's false throughout, but as I've shown you, Lordships, plainly it wasn't. Plainly it wasn't. That's the point in time which I was going to address your Lordships very briefly in relation to the application to admit the new evidence. We invited your Lordships to look at, this is in the second witness statement of Mr. Elam, dated in June last year. I don't know whether your Lordships have read that witness statement on the Debeni essay basis or not.
Yes.
Yes.
There seems to be a bit of a hole in it, because it doesn't actually say in clear terms when you got this new evidence or how. All we know is it was from the quotes former CEO, whoever that may be. It seems to have been someone with whom your clients were in contact with all along. And it was following the hearing. But there's a great lack of specificity as to how and when this new evidence was obtained.
Well, I can do no better than what's said in the evidence.
To be sure.
Obviously. Mr. Elam says, so Mr. Elam being JNFX's solicitor, explains that it is obtained after the hearing. So you do have his evidence that is the fact, that it's obtained subsequently. So if I turn it up, it's in the supplementary bundle, tab 5B, page 119.
But just approaching it in general terms.
Yes.
Would you accept that there's a difference between evidence that you didn't know might exist and falls into your lap after a decision, and evidence that you knew all along existed but you didn't ask for?
Well, my lord, we would accept that distinction if it was after a trial. In our respectful submission, there is a proper distinction to be drawn between late evidence after the matters have been concluded at a trial and evidence which comes to light after an interim hearing, at which originally it was going to be a request for summary judgment on everything, which was plainly inappropriate, as is recognised by the fact that Mr. Giwa abandoned a lot of it. Not to have done, by that stage, a comprehensive trawl of all the evidence that might possibly be available, and indeed the evidence that Mr. Elam has explained himself he would expect to be gathering at the stage of disclosure, is something in our submissions which should be forgiven, not least in circumstances where Mr. Giwa himself has explained in his reconciliation narrative that the process which he undertook took some 4 months and with the assistance of solicitors, when all the documents are within his knowledge. So,
simplifying, would I be correct in summarising your submission as being, yes, we could have got it before, but this being a summary judgment application, we shouldn't have been criticised for not having obtained it before.
Can I turn my back for a moment? My Lord, in theory, yes, the request in relation to pro-trade could have been made, but obviously up to that point, those instructing me were fighting the summary judgment application on a whole variety of fronts at a very early stage of the proceedings. And as Mr. Elam explains, it's only having obtained what they then obtained from pro-trade that enabled them to work out the significance of various other documents. But I'd also make the submission that personally here, this is not new evidence that's then challenged by Mr. Giwa. We say this new evidence shows that on the 21st of September, Mr. Mervyn was performing a contract with Mr. Giwa for a client called Technocrat and was performing by the delivery of US dollars on that date. That fact, which is what we say the evidence shows, is not disputed. And indeed, one sees that in the skeleton argument for my learned friends, where they positively say, Mr. Giwa says that this payment to Technocrat was the last payment which Mr. Mervyn fulfilled. So it's not a situation where I need to trouble your lordship in relation to, the veracity of what it shows. Actually, the very fact is admitted. It's a very simple fact. And in our submission, it is relevant. And is, again, in our submission, should be admitted in evidence in those circumstances.
I think you rely on some authority in, is it Flitcraft, saying that the test is not quite the same.
Yes, I do. Perhaps if I just very briefly take your lordships to the relevant paragraphs on that, and then it might be an appropriate time to pause. It is, Lord Justice Nugee rightly identifies that it is the Flitcraft decision, which is tab 5 of the authorities volume. And the relevant paragraphs, which it probably suffices for me just to direct, or invite, I should say, your lordships to read, are paragraphs 44 through to 46.
Thank you.
Same criteria but with appropriate modification, and then the summary is at 46.
Yes.
Standard of diligence is not as exacting.
Yes. Indeed. Lord Justice Floyd there at 46.
Thank you.
Very good. We'll pause there and resume at 2 o'clock. How are you doing time-wise?
Dare I say it, and mindful that obviously I need to allow for interventions. I appreciate I've only got through the first 2 grounds, but the second ground is obviously rather more substantial. I indicated to my learned friend earlier that on the basis of notionally splitting the time in half and allowing time to reply, I was hoping to be finished by around 3-ish this afternoon. I will inevitably have to cut my cloth accordingly because there's a lot to cover, but I will seek to do that.
All right, very good.